Good morning. Welcome to Torts Week 1. Today we're going to be talking about the introduction to torts. If you're like many people, you probably got assigned this torts class having no idea what a tort was. Maybe it made you hungry, made you think of a sandwich or a pastry. But tort, believe it or not, is something even more prevalently litigated than crimes. They happen more frequently, and they make up more of the fabric of our society, a negative fabric of it, but most people have never heard of it. So today we're going to be introducing you to what a tort is, giving you a general overview of the civil justice system. But before we get started, let's talk about Abraham Lincoln, give you the quote of the week. So a young man, when Abraham Lincoln was a lawyer before he was president, he asked Abraham Lincoln for some advice because he was looking to become an attorney. And Abraham Lincoln wrote him a letter that said, among other things, this: "Let no young man, choosing the law for a calling, for a moment yield to the popular belief that lawyers are necessarily dishonest. Resolve to be honest at all events, and if in your own judgment you cannot be an honest lawyer, resolve to be honest without being a lawyer." So that's one of my favorite quotes from Abraham Lincoln. Obviously, it applies to anyone in the legal profession. It applies to men and women. It certainly applies to paralegals. Really important that we start your paralegal career, I just want to make that plug for honesty. And this theme will probably come up a few times throughout the class. It certainly will come up as you begin your career as a paralegal. So let's get into the tort terminology. Okay, the word tort is a wrongful injury to a person or their property. It derives from a French word meaning to twist. It's something bad someone does. It's not necessarily... Well, it has a bad result, even if the action itself wasn't bad. For example, we'll talk about negligence in the next unit, and you'll find that a tort, even if it's unintentional, but it causes harm, can be something that you can be held accountable for, and it actually is a tort. So a tort is any wrongful injury to a person or their property. Tortfeasor is the word for the person who commits the tort. And as you'll learn in other parts of this course and other units of this course, there are several sources of the law. Some of them are judges, the judicial branch. And tort is mostly derived from the judicial branch, from decisions that judges and courts make in specific cases. That's called common law. And then there are also some statutes that outline some torts, but most torts are judicial or common law. And I find that if I compare a tort with a crime, it helps people understand or have a better idea of what a tort is, because everyone understands what a crime is. So conceptually, you may not understand all the different parts of the crime, but we'll go over them, because conceptually it's a lot easier to understand what a tort is once you compare it to a crime. So crime is technically a wrong against society. Now we think of, there's a victim, yes, right? There's a murder victim, a rape victim, a robbery, theft, burglary. There's typically a victim. But the fact that they're crimes means it offends our society's sense of right and wrong. And so in a very general sense, the way crimes are written, it is an offense against society, not just the victim. And because it is society that is wronged, it is society or the government that's responsible for enforcing the wrong. So in the criminal realm, you have prosecutors, right? And they're paid by the government, and they are the ones who get to choose whether they're going to pursue a case. And you have the police that are investigating the case. Those are also government employees. And so it is the government, through the police and the prosecution, that investigate and then decide whether to prosecute a certain case as a crime. Okay, so the government enforces criminal behavior, or enforces the punishment or the consequences for criminal behavior. And in a criminal case, the burden of proof is high. You've probably heard the phrase beyond a reasonable doubt. That's the highest burden of proof that exists in our justice system, either criminal or civil. You have to eliminate all reasonable doubt if you're going to convict someone. And so the burden of proof is rather high, and that's because the consequences of being found guilty, and that's the question in a criminal court, is guilty or not guilty. The consequences for being proven guilty are quite severe. It could range anywhere from a fine to death, right? Anything in between, right? Typical in between being a combination of fine and imprisonment. And so if you're found guilty, they can take away your money, they can take away your freedom, and in extreme cases, they can even take away your life. And so because those consequences are so severe, we've got to have the burden of proof pretty high. And so that's kind of the criminal world, and you're probably familiar with it Hopefully not from personal experience, but maybe from watching TV or movies. Now, a tort, on the other hand, is a little bit different because the victim in a tort is the actual victim, right? We have wronged the victim, and in a certain sense, it does offend society's sense of right and wrong. But in a civil case or in torts, it is the victim himself or herself that has to enforce the consequences of the tort, because no government is going to do it for you, right? They'll pursue crimes, not all of them, some of them within their discretion and the ones they choose to pursue. But with a tort, it's up to the person who's been wronged to decide whether they want to do something about it. And so legal action is brought by the actual victim, and we call that a lawsuit. Okay, so you can sue someone to enforce your civil rights. The burden of proof in a tort case or a civil case is much lower. Typically, it's going to be what we call preponderance of the evidence. And all that means is more likely than not that my version is true. So preponderance is, if you could picture scales, it just means the plaintiff, the person, the victim, the person bringing the lawsuit, has to convince the trier of fact, which is going to be either the judge or the jury, the one deciding the case, that their version of events is at least just a little bit more likely than the defense's version. If they can just get over that slight burden, then the plaintiff should win. There are other burdens of proof in tort cases. That's the most common one. We'll actually cover one of the other ones when we talk about fraud in a couple units from now. But as a general rule, the burden of proof is much lower. And that's why, for example, in O.J. Simpson's case, he had two cases, right? He had a criminal case because the same action can be both a crime and a tort. And so an alleged murder of someone is a crime, and it's also the tort of wrongful death. And so he was prosecuted for the crime of murder, and the prosecution was not able to meet their burden of proof. They were not able to convince a jury beyond a reasonable doubt that O.J. Simpson had committed that murder. In the civil case, however, the burden of proof was much lower, and the survivors, the family members of Ron Goldman, were able to convince a jury to that lower standard that O.J. Simpson had committed the tort of wrongful death. And so he was found not guilty in the criminal case, but he was found liable in the civil case. And there are other differences between them and other protections. For example, in a criminal case, you can't compel someone to testify against themselves. So the prosecution in O.J. Simpson's criminal case could not call him to the stand and ask him to provide an alibi, for example. Whereas in a tort case, they could call him, and they did call him, and they had O.J. Simpson testify, and the jurors were apparently unconvinced by his testimony because they found him liable for the wrongful death of his victims. And so that's a lower burden of proof. And going with that lower burden of proof is the fact that the consequences are lighter in a tort case, because the most you're going to get in a tort case, in almost any case, is money damages, and that is a monetary equivalent of the loss caused by the tort. And we'll talk about damages in further detail later. There are other potential consequences that we'll talk about, none of them more severe. None of them as severe as in a crime. But for the most part, you're going to get money damages or money awarded for losses incurred by the wrongful act or the tort. So that's very generally the difference between a crime and a tort. Hopefully helps you understand what a tort is and how the civil justice system fits in with the criminal justice system. Now, one other major difference, and I'm not quite sure where this came to be. It may very well be something we can lay at the feet of the insurance industry and their tort reform efforts. I'm not sure. But there's a stigma attached with suing someone, okay? So typically people who sue people, that's not something they advertise. Maybe they're a little bit embarrassed about it. People, if they've been wronged, they don't think to sue someone. That's something other people do. They don't want to be litigious. They don't want to be the one suing people. So there's this stigma attached to filing a lawsuit for a tort, even though as a society we generally uphold the virtue of accountability, right? When parents don't discipline their kids, for example, you're at a store and kids are running wild, you get judgmental looks, people going, why aren't those parents enforcing the rules with their kids? Get your kids in line. I mean, as a general rule, we value accountability. We want people to be held accountable. But for some reason, and this is incongruous with some of the purpose behind tort law, even though we value personal accountability as a societal value, we're hesitant to hold others accountable, even though in the same instance, when police hold people accountable for crimes, generally we're okay with that, right? We feel safer knowing the police are out there. Obviously there are exceptions, but as a general rule, there's no stigma against prosecuting someone for committing a crime the same way there is for suing someone for committing a tort. And again, I'm not sure the reason, but it is there, and it's something that highlights one of the other differences between a crime and a tort. So why? What's the why behind tort law? And you really have to, for the most part, read some pretty old cases and old treatises to get this. Most new cases don't really discuss the purpose behind tort law, although I think the smart judges do because they understand the moving pieces. But let's just go over some of the purposes behind tort law and the reason tort law was established. One is to protect people and their property from unjust injury. Okay, so there's a set of rules that if followed, allow for protection against property, and that's through the second point. That's compensation and this idea of responsibility or accountability. So if someone damages your property or injures you, there's a mechanism that you can hold them accountable for it and you get compensated for it, and that make you whole, so to speak, right? That's the second purpose, is to make you whole, at least to the extent that the tort system can. And there's obviously the judge can't order the tortfeasor to heal the wounds of the plaintiff. That wouldn't be possible, but he can order the person to pay for the medical doctors who attempted just that, and he can pay for the pain and suffering that the person experienced. And that in turn kind of sustains this third point, and that's encouraging minimal standards of social conduct. In other words, if you know, and the third and fourth go together too, the deterring violations of those standards of conduct. So if you know that there are rules, if we know that if we're texting and driving, there's a good chance we could rear end someone. That's dangerous. It's illegal. And we text and drive and then we hurt someone, that fulfills the first two, and that we can compensate them for it. But ideally too, because we know that that's the rule and that there's an increased risk of injury, that we're not going to text when we drive, right? That's this idea behind encouraging minimal standards of social conduct. We make it known that these are the rules and there's a mechanism for an enforcement of the rules, hoping that this knowledge will encourage people to not violate the rules. Numbers 5 and 6 are a little different. They don't go with one another, but number 5 is kind of interesting if you think about it, but it's almost like one of the tenets of socialism almost, but many, and only applies in certain circumstances. And that is, hey, there are certain losses that as a society that are going to be incurred. You know, we're in a post-industrial era, so we have machines and we have cars, and you know, they're fast moving and moving parts and all sorts of ways people can get injured. And so the law kind of says, hey, there are ways that we can minimize the burden. So if one person gets hurt and they incur a lot of damage, they won't have to bear the burden of that cost alone. And so a couple examples are insurance, for example. It's a legal requirement if you're going to be on the road to purchase car insurance, and that is if you do damage in excess of what you personally can afford to pay, then the insurance, that's why we have insurance, so that we don't have to look to your assets. You've purchased insurance and insurance will pay, and that is money taken from everyone who's paying their premium every month. So the damage you cause is allocated among all the premium payers of that insurance company, and so it allocates the loss among lots of different people. And another way the fifth bullet is kind of fulfilled has to do with product defect case. And we'll learn in a unit or two that when it comes to product defect, anyone who is in the chain of distribution or anyone involved in putting that product on the market, whether they designed it, they manufacture it, they were the wholesaler, retailer, every one of those is responsible for paying for the injury. And it's not because they've done anything wrong, it's because at one point the courts just decided, you know, speaking on behalf of the public, hey, these people are making money off of this, so if someone gets injured, they're going to share the cost. So that's a couple different ways that losses can be allocated or spread among different participants of society. And then the last one, This is really actually pretty powerful. And I don't know if you guys have ever been the victim of a crime where you felt like the police or the prosecution just didn't do enough. Maybe they didn't even investigate the case. It wasn't a big enough deal for them. Or maybe they did prosecute the guy, but then they let him off easy through some plea deal, and you just didn't feel like they had your best interest in mind, or they didn't prosecute it enough. And you don't actually have any say in that, right? The police, they don't have to investigate everything, and the prosecutor doesn't have to prosecute everything, and there's nothing you can do about it. But that's part of the reason we have tort law, is if you're dissatisfied with the way the criminal case goes, or even if you don't care and you want to pursue things on your own, you have the power to prosecute your civil case, as you know, and either settle or not settle, or take it all the way to trial, and that's your choice and your power, and you can choose to what extent you're going to hold someone accountable for something wrong that they've done, and so you can get justice that way. All right, so let's go through a little bit of a chronology. This is kind of a typical timeline. This is not going to be universally true in all cases, but in a law office, this is kind of usually how you'll see it unfold. For example, if you'll get the most perspective of this if you work for a plaintiff's firm where you're representing plaintiffs in tort cases. You'll see this as well in defense firms, although they don't typically get involved until later on in the process. But if you are a paralegal in a firm that does tort law, you'll be familiar with this even if the firm isn't involved at every stage. So obviously, the first thing is a tort is committed. The lawyer's never there for that. Okay. In fact, if a lawyer were to witness a car crash, the lawyer can't both be a witness and the lawyer in that case. Okay. So as a paralegal, you're going to be gathering information about what happened and how these people were injured. You'll find out what happened, and with the training you'll receive in this course, hopefully you'll have enough knowledge to be able to identify whether it actually was a tort or whether it wasn't. But tort's committed. Someone's rear-ended, someone's defamed, someone's defrauded. Whatever the tort is, it happens outside the presence of the law office, and so one of the jobs as a paralegal is to gather as much information we can to find out about what happened, so we can figure out if it's actionable or if it's something that you actually have a basis for pursuing legally. And so then at a certain point, this person who's been injured, they hire an attorney, presumably. If they don't, then this whole process is different and you're never involved and it doesn't matter. But if they hire an attorney, then you're going to be gathering information, and if you decide that there's a case there, a tort was committed, it was within the statute of limitations, there's no other big fact that precludes the pursuit of this claim, then the first thing that you're going to do as a paralegal on behalf of the attorney is you're going to create a letter. We call it the notice or preservation of evidence letter. You're putting the tortfeasor or their insurance company on notice that you're making a claim and asking them to preserve evidence. So, hey, the letter is basically, and you'll be drafting one of these letters. Hey, dear insurance company, this is the such and such law firm. So-and-so person was in a car crash on this date or slipped in your store on this date. We're putting on notice that they've hired us. We're going to be representing them. Please keep any relevant evidence you had. Don't destroy it. Preserve it. Get the surveillance video and save it, and whatever else, because we're going to need that later on. And then they are now put on notice. And then some time typically passes between when you put them on notice and when you send a demand letter, right? Because you're going to be gathering medical records and you're going to be figuring out exactly how badly hurt they are. You want to know what the total of their medical bills are, what their prognosis is. Did they get better, or do we expect this to last into the long term? And you put together a demand letter where you summarize what happened, what law applies, how much damage was done, and how much it's going to take to settle the case, and you send that off. And then negotiations probably begin. Sometimes the insurance company just denies the claim, and then negotiations are over. Other times they'll make you an offer. It's rarely going to be what you ask for. And then there's negotiations that go back and forth that may result in a settlement. If it results in a settlement, you sign an agreement, case is over, and the client gets paid. If you do not reach a settlement, then the next step is litigation. And so litigation is that word, you've heard it before, but that's once you file a complaint The complaint is the document that initiates the lawsuit, and we'll be going over all those terms in your other class, in the practicum class. But tort litigation begins once you've realized that you're not going to be able to settle this informally, so you want to get the courts involved, so you prepare that complaint, which is the litigation initiating document. You file the complaint, now you've filed a lawsuit, you've initiated a lawsuit, the courts are involved, and you're involved in litigation, okay? And so tort litigation begins. Now, let's just briefly, and you will be drafting a complaint. We'll teach you how to draft a complaint in the practicum course. But for purposes of getting kind of that 50,000 foot view of the tort litigation process, I'm just briefly going to give you an idea of what a complaint is so you can understand. Okay, so in the complaint, you're going to have several sections. You're going to make the jurisdictional allegations. Those are allegations related to, which court you're filing in, and it's going to kind of explain without a real detailed explanation, but it's going to give the court enough information to know why you're filing in their court as opposed to some other court. Then you're going to have a general allegations section, and in that you're going to kind of tell the story of what happened. So-and-so was driving in this vehicle heading this way on this street. They weren't paying attention. They rear-ended so-and-so. So-and-so was injured, right? It could be as simple as that. You're basically, hey, this is a rear-end car crash case. You're making the specific allegations to tell that story. And then you get into the claim-specific allegations, and that's where you have to identify the tort that you're bringing. And we'll cover about 20 torts in this course. Most injury cases, if not all, almost everyone, have an element of negligence in them. Okay, so that's going to be the first tort we learn. Other torts, and one that we'll give you an example of for purposes of this kind of explanation, is defamation, right? People have heard of slander or libel. Those are both forms of defamation. And so in the claim-specific allegations, that's where you're identifying which torts you're bringing, and you're making allegations that are specific to that tort. Okay, there's like a recipe for each tort, and you have to make sure that you've got all the ingredients in that. The claim-specific allegations, you've got to have every ingredient for that recipe for that tort in that portion of it. And then there's a prayer for relief, which goes at the end of your complaint, and that basically you tell the court what it is you want out of this. Why, when filing a lawsuit, what do I want? I want money, I want attorney's fees, I want an injunction, whatever it is. That's in your claim specific, or your prayer for relief, rather. Now, one thing you have to know right off the bat is that just like the prosecution bears the burden of proof in a criminal case, the plaintiff, or the one initiating the lawsuit, the victim, the one who's been harmed, they bear the burden of proof in a civil lawsuit. And what that means is they have to bring the evidence to the jury, to the fact finder. They have to be able to show, here's what happened, here's why it's enough to prove that defamation occurred. If the plaintiff doesn't bring enough, the defendant wins. In fact, the defendant doesn't have to lift a finger. They can just sit back and do nothing. If the plaintiff doesn't bring enough, then the defendant wins. That's what bearing the burden of proof means. It also means that if it's close, and by the way, the defendant doesn't just sit back. They bring their own evidence to try and tilt the scales in the other direction. Because if it's really close and the jury can't really decide which side should win, the defendant wins. Because the plaintiff has to have that evidence weigh, right? The preponderance of the evidence. It has to weigh just a tad in their favor. And so tie goes to the runner, you've heard in baseball. Well, tie goes to the defendant. That's another way of looking at this burden of proof idea in a civil lawsuit. All right. So when it comes to claim-specific allegations, I told you that there's this ingredient, this recipe with a list of ingredients that you have to include, okay? And those are called elements. So we'll talk about that in the next slide probably. Actually, it's at the end of this one and probably at the next one. But here's what you need to know. When you're drafting a complaint, you have to meet what's called the minimum pleading standard. And that standard is going to differ from jurisdiction to jurisdiction. And so some jurisdictions have what's called a notice pleading standard. And that's the lowest standard, right? And that's what they used to use in federal court. It's now been replaced by plausibility. But in many states, notice pleading is still the standard. And that is essentially, you have to include enough in your complaint, enough information that it puts the defendant on notice of what they're being sued for. oh, it's defamation. Oh, it's from this behavior of this date, right? So they have enough to understand what's going on, why they're being sued, so they can respond. So pretty low, okay? Plausibility standard is the standard now used in federal court, and that is not just put them on notice, but you have to allege enough facts that your claims are plausible. Right? It supports a plausible claim for relief. So it's a little bit higher, a little bit different. And then fact pleading is kind of the highest. It's still not that high, but you have to include all facts to back up your allegations. So if you're in a notice pleading state, you're not going to be filling your complaint chock full of facts because you don't need to. And facts change, or at least your understanding of the facts change throughout discovery. You find out new things, and you don't want to allege all these facts, find out you're wrong later. And so with a notice pleading, you're not going to put as many facts, just enough to put them on notice typically. In a fact pleading state, you got to put all those facts in that support your allegations. So there's kind of a gradation of how specific you need to be, starting from notice pleading and all the way up to fact pleading. And at a minimum, you have to include all those ingredients in the recipe, which we call elements. Okay, all the elements of a claim have to be alleged. And depending on how many facts you need to support each element differs based on the jurisdiction and the pleading requirement you're in. But in every case, you have to allege each ingredient or each element of a claim. Okay, so I've kind of already explained what an element is. It's those ingredients to the recipe, but every tort has a different recipe or different set of elements. Okay, now these elements, they're going to be state specific. So depending on what state you're in, you're going to have to figure out what they are. They're probably going to, they're going to be very similar from state to state, but there are variances. So you're going to have to be familiar with your own state's torts. Okay. So here's an example with defamation, and I'm just giving you, these elements aren't going to be universal in every state, but these are the elements in some states. Okay. To prove defamation, you must prove. Now these are the ingredients in the recipe, all of which must be proven, all of which must be present to win the case for the plaintiff. A false statement by the defendant about the plaintiff, an unprivileged publication to a third person, fault amounting at least to negligence, and damages. Now, we're going to cover defamation later on in greater detail. I'm just showing you this to illustrate how one claim would work throughout the litigation process. So you don't necessarily understand what all these means, but just real briefly, false statement by a defendant about plaintiff is pretty self-explanatory. But when it says an unprivileged publication to a third person, what that means is that false statement was shared with someone other than the plaintiff. Okay, so you're telling someone something about the plaintiff, and that's got to be a non-privileged communication. So it can't be you're confessing to your priest, or you're talking to your doctor, or your lawyer, or your wife. Those are privileged. So it's got to be some non-privileged communication. Okay, and then fault amounting at least to negligence, just real briefly, means that the person making this statement has to be careless about whether the statement's true or false. They don't have to know that it's a false statement, but they at least have to be careless about whether it's true or false. It's not something they know for sure is true, and they're saying it anyway. Okay, and the damages is typically damage to reputation. Okay, so if you're drafting a complaint for defamation, you are going to want to be familiar with each of those ingredients or elements and include facts in an allegation sufficient to meet every ingredient. So you're throwing every ingredient into the mixing bowl. Okay, so here would be an example of how you would draft those claim-specific portion of your complaint for defamation. Defendant, so these are allegations, right? Defendant told plaintiff's girlfriend that plaintiff had chlamydia. So there you've got a statement made by the defendant to someone else. Okay, defendant's statement was not privileged. All right, so it's an unprivileged statement. Plaintiff does not in fact have chlamydia and never has, so it's a false statement. Defendant knew plaintiff did not have chlamydia. Okay, so it's at least negligence. That's knowledge, which is more than negligence. Okay, and as a result of defendant's false statement, plaintiff suffered damages. That's the damages element. So you see how we have taken what actually happened, we've turned it into allegations that meet every element. So that's how you draft a complaint. All right, there you go. Now you have a slide that shows how it matches with the elements. Okay. So let's talk about this. Would it meet even the strictest pleading standard, the fact pleading standard? Probably, because we've got all the facts that you need to meet those elements, right? The facts: chlamydia, girlfriend, never had chlamydia. Those are facts. And if you wanted to really make it like more motion to dismiss proof, make sure that it's really going to survive, you could add more facts. When were the statements made? What's the name of the plaintiff's girlfriend? What were the exact words? How did this damage the plaintiff's reputation? Did his girlfriend break up with him and no other girl would now date him because this word is spread that he has chlamydia even though he doesn't? So it probably meet even the strictest pleading state. But in a notice pleading state, you just have to say, defendant made a false statement about plaintiff. That statement was unprivileged. The defendant did not have reason to believe the statement was true, etc. Right? Just we're not really getting into the facts. We just make the allegations now, and we've at least in the general allegations part alleged some facts, so we know it's about chlamydia, for example. But that in a notice pleading state, that would probably be enough. All right. So, how do you find the elements of a tort? Right? There's no one way, and in different states you're going to have different tools available to you. But because most torts are common law, which remember that means they're derived from the judicial branch or they're based on written court decisions on that specific case, that's where the elements are going to be contained in the language of the case. And as we'll go into a little more detail, there's kind of a way that these cases come to be, right? You have something bad happens to them. Maybe it's a defamation case. Someone says something bad about them. They sue them. They go to trial. One party wins, one party loses. And then the losing party then appeals that to an appellate court and says, hey, the judge got it wrong, right? The judge was making bad rulings, should have sustained this objection, but he overruled it, and that affected the outcome of the case, and therefore the jury didn't get the right information, and so the outcome was wrong. And then the appellate court analyzes the law and the rules, and then they write a written opinion as to whether the rules were followed, and that's what we call a case. When you read a case, it's that judicial opinion about whether the lower court did the right thing. And so when they're analyzing it, the complaint may be that have something to do with defamation, and the plaintiff may say, hey, we weren't able to get evidence of this, and we have to prove that, and therefore it prejudiced us. And so the court may, in its opinion, go, all right, to prove defamation, the plaintiff has to prove this in this state, A, B, C, D. These are the elements. And then they discuss what the court did and whether it was fair or not, and they reach a decision. Well, now that decision that the appellate court made, that's a published case. Typically, it's not always published, but we'll get into that later. Now there's this case, and it applies to all future cases within the jurisdiction of that appellate court. So all the trial courts underneath that appellate court now have to follow that decision, and so that's how tort law is born. And so you can find the elements by looking through these cases, but it's not always really easy to find. Because if you're running a search, say you have a subscription to Westlaw or Lexis, which are a database of all these cases, or maybe you're looking on Google Scholar, you can't necessarily just type in the search queue elements of defamation, because the court isn't necessarily writing the elements of defamation are. They don't necessarily use the word elements. Like in my example, the court said, to prove defamation in this state, plaintiff must prove the following. So the word element wasn't even used there. And so it might be a little hard to find. Or maybe the court, instead of using the word defamation, they used the term libel because it was written down. Or maybe it's an older case and they used the word calumny, which is that was what they called defamation a long time ago. And so finding elements might be challenging just because you don't know which search terms to use. So you could spend a bunch of time using different search terms or using a thesaurus to come up with different words for defamation and different words for elements and trying to find it. And you probably will eventually be able to find it. But there are also other ways to do that. So let's go over the pros and cons of each, okay? I already mentioned Westlaw or Lexis. They're always up to date. They are edited by attorneys. When you read a case, it's flagged. It'll tell you whether the case is still good law, so you're not accidentally relying on a case that's been overturned by a subsequent case. So those are pros. Some of the cons are, number one, it's very expensive, so the firm you're at may not have it. Most firms now have it, but some of them don't. And their search algorithm is not that great. I mean, they pay someone to come up with this algorithm, and it's fine, but we're used to Google, and Google's like awesome when it comes to knowing what you're looking for and giving you what you're looking for. And so it's a little bit not as intuitive to use the search string in Westlaw or Lexis. So you can use Google, right? Google Scholar, it's free. It is always up to date. It's got better searching because it uses Google's search algorithm. The problem is you still need to use the right words, right, to a certain extent. And it's not going to tell you whether the cases are good or bad because Google is just putting them out there for you to search and making them available, but they're not hiring an attorney to read the case and then check all the other cases to see if this case has been overruled. So you'll read a case on Google and it won't tell you if it's still good law or if it's since been overturned. So that's one con of Google. Okay, and I mentioned Keysight and Shepard's. Keysight is Westlaw's their marking system where they tell you whether the case is still good, and Shepard's is LexisNexis's. Okay. So a lot of times though, you can find either a website or a published book that says, that lists all the elements. Like in my state in Nevada, there's a website. There's two websites actually. One is truecounsel.com, TRUCOUNSEL. There's no E in true, but truecounsel.com, and then the other is like law.info or something like that. I don't remember the name of it, but they did all the work and they went and found the elements from the different torts and they just stuck them there, and then they got the case citations that show you where they came from. And then there are published books as well. In fact, I think I have one here. Yes, right here. So this is one here. It's called Elements of Claims and Defenses in Nevada. And I think there are like 3 different people who have done it, where you can just look up a certain tort and then it'll tell you all the elements and then it'll lay out all the common defenses for that. So if you have something like that for your state, or if you find a website, Florida has a really good website that has all the elements of the torts on it. That can be very helpful and save you a lot of time instead of trying to search through all the cases. So, all right, so you got to keep these elements. You got to be familiar with them, and that's part of what we'll teach you in the course. Is these 20 torts we go over will all give you the elements, the common elements, right? Give you an idea. Every state might be slightly different, but you're going to need to be familiar with the evidence because that drives everything during litigation, even pre-litigation. Okay, so I'll kind of give you an idea of how the elements play in various stages of litigation, well, of the whole case. You've already seen how it fits with a complaint, where you've got to know what the elements are because you have to make allegations for each element, or your complaint's going to get thrown out because a motion to dismiss is going to be granted. Also, in the initial consultation, or even the initial phone call, paralegals may be doing that. Probably at least doing the phone call, sometimes also doing the initial consultation. And you're going to need to know the elements because you need to know which questions to ask to determine whether they have a case. So someone may call and say, someone slandered me. I've been a victim of slander. The first question you're going to want to ask is, what did they say? What was their statement? And I've had experience with this, and people, they were so mean, and it was embarrassing, and they insulted me, and all right, but what were their exact words? Oh, it was terrible. No, sir, what were their exact words? Oh, they said, you're such an ugly witch. Okay, all right, well, that's not defamation, right? We'll learn about that later, but you got to know what questions to ask. For example, did anyone else witness it? Well, no, it was just me and him. Well, there's no publication to a third party. And if they call you ugly, that's not a false statement of fact. That's an opinion, which is protected. They can offer their opinions, right? So you got to know which questions to ask so that you can help screen and then help determine whether to even set up the initial consultation. So elements are going to drive everything in your case. All right, so back to the slide. So once you file a lawsuit, there are some kind of preliminary procedural things that need to be done, but then discovery begins. Discovery is the time you're given to gather information. So you have written questions you can ask, you can take depositions, you can do interviews, and you can go inspect locations, and there's all sorts of that, which we'll talk about later. But you need to know what the elements are because you need to know, all right, I need to prove that this statement was false. So, I'm kind of going over this. Yeah, this just illustrates the importance of knowing the elements for every stage of the case. So here's my example. Back to the chlamydia example. I need to know the elements because I need to know what information to gather. So first off, I need to prove that my client does not have chlamydia, because that goes to whether the statement was false. Because if someone says he has chlamydia and he doesn't, I can prove that that was false, and that's one of the elements I have to prove. So then I'm going to get medical records, right? Recent ones that show that he doesn't have chlamydia. And then maybe I'm going to have an expert testify that chlamydia doesn't go away. So it's not possible that he had it when the statement was made and he doesn't have it now. If he had it then, he would have it now, and the fact that he doesn't have it now means we know he never had it, and that way we can prove the statement is false. We need to be able to prove that this damaged the defendant, right? So it could be that the plaintiff, your client, could be that the plaintiff has HIV. And so telling someone that he has chlamydia doesn't really affect his reputation, because everyone already knows he has HIV. And so girls aren't dating him anyway. I mean, I don't know, right? But that would be one way. The defendant, for example, could prove that maybe his reputation wasn't harmed because, he has 6 STDs. So the fact that the guy got it wrong and it was actually herpes and the clap and not chlamydia, even though it was technically false, it didn't damage his reputation because he does have these other things. And so therefore the defense should win because the plaintiff can't prove the damage to reputation. So you got to kind of think in context, the elements. If I have to prove that this statement was made to a third party, then I'm going to want to take the deposition of the girlfriend, and the girlfriend's going to say, yeah, he told me that. And then, okay, now we've got testamentary proof that the guy told the girlfriend, made this statement to the girlfriend. Okay? So the discovery is driven by the elements you have to prove, along with, we haven't really talked about this yet, but the defenses. The defendant has defenses, and the defendant has to prove their affirmative defenses, and so that's going to drive part of discovery too. All right. So throughout litigation, you have the opportunity to file a motion. And a motion is really just, it's a vehicle to get a court order. It's a way to get the court to give you something, or to prevent the other side from getting something. So maybe you file a lawsuit and you can't find the defendant to serve him, right? To give him the summons and the complaint. You can't find him. And so there's a mechanism. If you've done everything you can to find him, instead of handing it to them personally, like typically you have to do, you can get court permission to publish notice of the lawsuit in the newspaper, and then they're counted as served, right? So you can file a motion, ask for the court for that, or for more time for discovery, or to throw the plaintiff's case out, ask for attorney's fees. Anytime you want something and the other side isn't willing to give it to you voluntarily, you can file a motion to the court. You can outline the reasons that you think you're entitled to it. So you're going to kind of juxtapose the facts of your case with what the rules or the law says you're entitled to, explain why they match. The other side gets an opportunity to respond typically, and then the court makes a decision and issues an order. So that's what motion practice is. And then there may be opportunities, and in some different types of cases this is mandatory. You have to at least try and attempt to reach a resolution by alternative means, alternative to a jury trial. And so we'll get into a little bit this later, but mediations, arbitration, settlement conference, those are the type of things, in addition to informal settlement discussions, that you can do either before litigation or during litigation or even during trial. At any point, you can make attempts to resolve the case before a jury makes a decision, and that's often encouraged. And so that often becomes part of the litigation process as well. We'll learn more specifics about these in the practicum course. All right. And then to kind of wrap up this litigation timeline, you have trial, right? Now the paralegal's role for trial, sometimes you'll actually be at the trial and you may be jury spotting and taking notes on the reactions of the jury to certain questions, or you may be there kind of making sure the witnesses are ready and making sure the next witness to be called is lined up and coordinating the witness calendars and stuff like that. Or you may be providing support from the office, but definitely most of what you'll be doing to prepare for trial is going to be in the weeks and couple months before trial, as you are filing motions in limine that either you or the attorney prepares. You're going to be putting the exhibits together in a binder. You're going to be ordering, getting demonstrative like big prints printed or ordered. You, you may be calling the witnesses and scheduling times for them to come in. You may be preparing the witnesses to a certain extent for their testimony, or asking them about what they know, give that to the attorney and have him or her take over. It gets very busy at a law firm before trial, and if you're a paralegal that's involved in trial stuff, that's no exception. So this takes us through kind of from what a tort is, from when a tort begins to litigation, to what happens in litigation, what drives what you're going to be doing through discovery and litigation, and that's the elements, and then all the way through trial. And then after a trial there may be an opportunity for appeal. There's other post-trial procedures. You may request fees and costs. You'll have to file the judgment. And then if you get the judgment and they're not paying it, you may have to execute the judgment, meaning go garnish their wages or bank accounts, or seize their car or their house or other assets. So there's also a lot to do after the trial. And then once you've got your judgment, it's been paid, or the case has been appealed and decided, and then you've gotten paid or you lose, then the case is over and you can close it. So a case gets started when they hire you after the tort occurs, and then it gets concluded either if you settle in the meantime, or you take it all the way through to a loss or a judgment and possibly appeal.